Hello, everyone. Hello, everyone. Today is a very important program, and we are definitely going to be discussing the Clar Foundation versus Asset Recovery and Property Retrieval Task Force case that is currently at the Supreme Court. Just to give you a little background before we move into what we are going to be discussing today. The Asset Recovery and Property Retrieval Task Force that was set up by President Joseph Yuman Bwaka is a government body established to investigate and recover allegedly misappropriated public assets, initiated an inquiry, the AREPT inquiry involving the Clar Foundation, a non-profit organization associated with former First Lady Clar Marie Weah. As part of its investigation, AREPT sought financial and administrative records from the foundation and caused a writ of subpoena, duces taken, to be issued through Criminal Court A, compelling the foundation to produce specified documents. The Clar Hope Foundation filed a motion to quash the subpoena duces taken, arguing that the subpoena was overly broad and invasive. AREPT exceeded its lawful authority to request a subpoena duces taken, and the compelled production raised constitutional concerns, including due process and potential privilege issues. Now, Criminal Court A denied the motion to quash and order compliance with the subpoena. The foundation then appealed the ruling to the Supreme Court of Liberia, challenging the lower court decision and the legality of the compelled document production. The case is now before the Supreme Court of Liberia for review of the subpoena validity, and the constitutional question raised is, does AREPT have lawful authority to issue or cause the issuing of a subpoena duces taken, compelling a private foundation to produce financial and administrative documents? This is a question that we are going to be pondering today, and I will have as my guest Professor Anthony Amos Tiokofa to discuss this issue. So you can stay tuned as we bring you a very, very important edition of the Vote 24 TV Kakis Dialogue today, 26th of February, 2026. Stay tuned. Once again, welcome. We have few more minutes to start. I have with me here attorney Professor Amos Tiakofa. And today we are going to be looking at a very important case that has both legal and political undertone. But for the most part, we are going to be discussing it from the legal perspective. And so the case is the Clar Hope Foundation versus Asset Recovery and Property Retrieval Task Force. The Asset Recovery and Property Retrieval Task Force is a government body established to investigate and recover allegedly misappropriated public assets, initiated an inquiry, that is the AREPT initiated an inquiry involving the Clar Hope Foundation, a non-for-profit organization, associated with former First Lady Clar Marie Weah. As part of the investigation, AREPT sought financial and administrative records from the foundation and caused a writ of subpoena, duces taken, to be issued through Criminal Code A, compelling the foundation to produce specified document. The Clar Hope Foundation resisted the motion and resisted and filed a motion to quash the subpoena, arguing that the subpoena was overly broad and invasive. AREPT exceeded its lawful authority in that the compelled production raised constitutional questions, including due process and potential privilege issues. Criminal Code A denied a motion to quash and order compliance with the subpoena, that is the Clar Hope Foundation has to honor the subpoena duces taken, that is to produce all of the necessary documents that were specified by AREPT. The foundation then appealed the ruling to the Supreme Court of Liberia, challenging the lower court decision and the legality of the compelled document production. The case is now before the Supreme Court for review of the subpoena validity and the constitutional question raised. Now we are here to look at, among other things, whether AREPT have lawful authority to issue or cause to be issued a subpoena duces taken, compelling a private foundation to produce financial and administrative records. So we have with us Professor Amos Tiakofa, attorney at law, to help us delve through this issue through the Kakis dialogue. Welcome, Professor Kofa.
Andre, thank you. Thank you. How's it?
Fine. Yeah, you want to?
Oh, okay. Thank you, Bo. Yeah, as you rather.
We still have some time. You can just chip in a little bit because I'm going to play the promo again.
Okay. Go ahead, play the promo.
Oh, okay. Welcome, everyone. It's a wonderful day, and we are about to go right into our discussion. We are expecting today to have the Liberian ambassador to Minnesota, Dr. Orlando Jones, to join us later on in the program. So, welcome, Professor Kofa.
Thank you,
Welcome.
comrade.
Yeah.
Thank you
So,
so
can
much.
you make your introductory comment and
Oh,
yeah, regarding the issue we are discussing today? For our viewers, we are looking at the case involving the Clar Hope Foundation and the Asset Recovery Task Force.
yes, as you earlier on laid the premise, I think it's a wonderful conversation that we should all delve into, especially for you and myself and other people who have been privileged to have some legal education. Uh, this is one way that we can also exercise you know, our knowledge in the field of law, and it's the debate will always be there, there will always be the pros and the cons, but, depending on which side you try to support, just make a good case, and the public will decide. And I think that is why we are here to make sure that we add to the many voices that have been discussing this issue so that at least we can also provide our own insight as it relates to the judge's ruling, with respect to the production of the document that were being subpoenaed.
Yeah. So the first issue is knowing what the Asset Recovery and Task Force is. I don't I don't I don't really like the Asset Recovery Task Force because they talk more than they work, and most of what they do, I see that as showmanship. Because in Liberia now, the people care less about all of the the process and procedure. They only want to see that somebody was taken to court, and not necessarily taken to court. They want to see that, oh, people stole money and that funds were recovered. So the end is what the Liberian people are looking at. So they're not so particular about all of the goods that come from the process, right? So trying to politicize the process or make noise over it, or try to gain some sort of publicity over it, it doesn't matter to the Liberian people. So looking at this case, uh, the question now is whether the subpoena duces taken issued at the request of AREPT, the Asset Recovery Team, and enforced by the Criminal Code A, is lawful. Is a lawful exercise of investigative authority consistent with the Constitution. Or put another way, yes, I have Orlando Jones joining me here. So put another
Yeah,
way,
the ambassador
yeah,
to
the
Liberian
Liberian
ambassador to
ambassador to
Minnesota.
Minnesota.
Yes. I
If
salute
you,
you,
if
sir.
you have if you have not seen Orlando Jones when you come to Minnesota, you have not integrated well.
I know, right?
Or whether the asset recovery team, or request for a subpoena duces tecum is an overboard and constitutionally defective intrusion into the private entities' rights. So these are the question that immediately come, to the fore when we're looking at this issue. So yeah, can you respond to that?
Yeah, let the comrade introduce
Yeah.
himself and
Oh,
let. Yeah.
Orlando Jones, Comrade Orlando Jones.
But senior moderator also have to introduce me. Yeah, okay. You already introduced me. It's good to be on the Kaki dialogue, the Camara intellectual dialogue. Um, we have a senior professor here, Professor Amos Kofa. Well, what will be on the platform will be questioning him from every direction. He's an expert on the subject matter. So we're happy to have him on the platform so we can pick your brain and get some deeper understanding about and foundation and what to do and looking at the legal perspective, what and the government have the legal basis to challenge the Cloud Foundation. So I was thinking more will do deeper and I will jump in with some of my questions, my common sense question because I don't have the legal basis to ask all of the legal question, but I will come in with a common sense question. So I'm happy to be on the Kaki Dialogue.
Thank you, comrade. Thank you. So yeah, Bold, you asked whether or not the subpoena disasticum that was, filed by the court requesting the Clar Hope Foundation to produce the evidence in their possession to bring it to court, whether it was lawful. And I will say yes, it is.
Somebody has run alongside President Weir in the past.
Yeah.
That guy is
My man, your
OJ,
man Conor Gray is talking. Who
OJ,
talk?
you on the show and you play another
The
show.
man is listening to Conor Gray. Yeah, so yeah, the subpoena disasticum is I think it is in place. As we started off yesterday, I know the Clar Hope Foundation invoke the constitutional provision, Article 21 to be specific, Section H, that talks about self-incrimination. But the thing is, that provision, in my opinion, and from Supreme Court cases, we will go there. The Vani Shemon case, the Sapo Mani case, Vani Shemon and the Shemon law firm versus the Republic of Liberia, the court made it clear, that during regulatory and even criminal procedure, yes, document can be subpoenaed, can be requested. And the Fifth Amendment, the Fifth Amendment applies to America, but it's the counterpart version in Liberia we call the Article 21. That is the counterpart version, which protect individual from furnishing evidence against themselves, applies to natural humans, human beings, non-institutions like corporations. Corporations are not destined to enjoy that immunity. That constitutional coverage does not apply to foundation or corporation. It applies because the reasoning is corporation will not suffer any coercion for which self-incrimination should apply. Corporation will not go to jail, even though individuals will go to jail. But remember now, when you are incorporated, you are an artificial human. You take on the attribute of a human being as a corporation. So you can be sued and you can sue. But the reason you're not being covered as a natural person, because you know, the thing that natural person will feel if they send them to jail, they torture them. You can't just torture a corporation, but you can torture a human being to confess to a crime, whether they commit that or not. So because of that, human beings are the one are being protected under that clause, Article 21, Section H, against self-incrimination. And then even at that, there is still an exception. Not because you are a human and you are covered under the constitutional provision means that it is blanket. No. That self-incrimination only applies to verbal confession statement to be made and not physical evidence. So still, if you have physical evidence like your DNA, your fingerprints, those are not protected by that provision. So the court can, yes, send for documents that are physical and they are not words. You are not confessing to anything, but you have a document in your possession that the court wants. So long matter short, yes, that provision protect self-incrimination. You shouldn't be coerced to bring evidence against yourself, but that evidence is just testimonial evidence. That's what that provision protects. But physical evidence, no, you cannot enjoy from that constitutional provision. And categorically, entities like foundation and corporations are not covered by that constitutional provision. So the judge's decision to say that yes, bring the evidence that had been requested, it was in place, in my opinion.
All right, Professor Kofa, I had to say I want to do some elementary question here for our viewer to understand why we at this junction asking for evidence and government is deeper into the Clar Foundation. So, from your understanding and foundation in general around the world or in Liberia setting, how do they raise money for their operation? How do they acquire money? And to be more simple, can government sponsor foundation? Can government use the taxpayer money to sponsor foundation, or individual corporation or any public entity can help to sponsor foundation? How foundations is run? Give us some roadmap how it's set up in the legal framework and how they raise the money and why money is legal and why money is illegal. Because I know in the US that certain money in the foundation cannot take and certain money in foundation take. Can you set that basis for all?
Yeah, okay. So in terms of how foundation raise, especially non-for-profit organization, normally some will write proposal, they identify projects they want to undertake, they will seek donor funding, solicit, money from where to do people to help them fund those projects. And then at some point also, it's not a wrong thing when the government feels that a particular project is in the best interest of the people to subsidize. And that's why in the past, government could give some money. I think they still do it, give money to private entities, private school educational institutions that are not governmental institutions. All right. So yeah, government can give subsidies, but not to say government directly funding a particular project. I mean, if government feels that a particular project is in the best interest, is in public good, all right, and a private entity is undertaking that, I think it makes most sense if government will give a happy hand in the form of subsidies, which are not in any way illegal. All right. But
For
if
foundation?
government, But it's a different thing if government uses public funds to establish an entity, and instead of making it a public entity, you make it a private entity, yet a worth investigation. So I may not have all of the details for which I know AREPT is going into the Clar foundation, what they're sensing, what they're smelling. But notwithstanding, it's not a bad thing if they want to investigate to make sure that since she was she's the immediate past first lady and she acquired a foundation, that people think that there is an apparent of government falling in that foundation. I mean, it's not a bad thing to investigate. And that is why I'm saying
So
that, yeah, go ahead.
to follow on that question, because to my knowledge, I know that foundations and other entities that are doing non-profit or international NGOs in country, they report. There's a reporting system of the financial and operation of the entity. They usually report to, because it's all about planning, ministry, and the foreign affairs. Because most foundations that run in the country being sponsored by some international groups because the right project for grants and stuff. So this financial reports to be made to Ministry of Finance and Planning and the Foreign Ministry. So government get access to this document if they want to know where the funding is coming from, because and the foundation is liable or responsible to report this financial report to the entity, foreign affair, because if they get grant, who's sponsoring what, and so in this case, the asset recurring thing, I I guess they try to dig to find out what the source of the finance came from. Maybe there is no clear. So it's it's important for them to ask the who running the foundation to bring some document and how the foundation have been run, because this document should be found in the Ministry of and Finance and Planning and the Ministry of Foreign Affairs. So for my own, I did a little bit of research and said this financial reporting system, government should have access to it. So I don't know why government requesting them to bring it, because maybe they can find it nowhere where to funds, the fund of the of the program in the foundation.
What
So they
what I
gotta
do what I do know, and maybe I can just chip in before Professor Kofa speak on the matter. What I do know is that at the time we had the planning ministry, the planning ministry was basically trying to make sure that funding coming into the country was coordinated in such a way that it supports the development agenda. So donors were supporting the government at the same time, donors supporting the NGOs. So they were basically getting funding from the same sources, and government wanted to make sure that there is no duplication of
project. Yeah.
yeah, project and interventions. So that coordination was what happened, and ever since that time, the extent of the coordination has not been the financial reporting from NGOs, because we've not been reporting or sending financial report to government. The extent of the collaboration was that the government in compliance with some development protocol, they divided those institutions intervening in the country into sectors. So depending on what work you do, you are placed in a particular sector. And once you are in the sector, the ministry that oversees that particular sector is that ministry that gave you clearance on a regular basis. So to make sure that this is a legitimate organization and it is working in this sector legitimately. So the ministry most time will know. So Clar Foundation will obviously submit in terms of clearance of that institution to a particular ministry, say Ministry of Education, for example.
So it's not only planning because I dig deeper and they say financial reporting system, how they generate funds, what grant they receive, what is spending on. So
Yeah,
there's a
obviously the grant they
breakdown
receive,
annual. It's like an annual report that you report into a board because the planning ministry and the Ministry of Foreign Affairs it's a check, to checkmate, organization.
yeah,
So
I'm not sure about that. I don't think any organization is doing
I
like
think they get a
private
department.
organization.
I think the
But
ministry.
let's listen to Professor
Yeah,
Kofa.
then listen to Professor Kofa. Maybe he gets some
Well,
insight.
I think two of you, the two of you both, you still have a salient point you're making, and Orlando, to be specific, that is the reason why the framer of the Constitution, or in the interpretation of of Article 21, subsection H, that talks about self-incrimination. That is why corporations do not enjoy that right, because there is something we call the collective entity doctrine. Under that doctrine, corporations are offspring of state machinery, statutory offspring. They are created from statute. And in creating corporation, by incorporating them, the state reserved unto itself that right to regulate corporation and foundation. And when you fall in within that category, that regulatory framework, the state at any time can subpoena document to review, because the state has that authority. And that is why the code rule that they cannot use Article 21 to invade, the submission of the document that is being requested by ARA. And ARA is a functionary of the state. So in that case, that's why, because the foundation is created as a result of that, is organized under Liberian law and under the Business Association law of Liberia. The state, the governor of Liberia, got the right to ask for document, to look at your internal working. All right, to make sure that you're doing what you said you're doing, even if you are not a foundation, even all the corporations in Liberia. All right, all the businesses organized under the law of Liberia are subject to regulatory framework, and so the government at any time can subpoena document from them to know whether their operations are clear and they are not doing anything that is not in violation of the law.
So I will ask two questions.
All right,
The
Bo.
first one is on the side of AREPT. Does it make their case stronger, given the fact that the investigation they are carrying on concern a former public official, and they are basically trying to trace misappropriation or corruption within the public sector?
I think so. And from the ruling, I mean, we can predict. And given the Vani Shemon case in the Sapo Malin scenario, Vani raised the same argument that their bank account that was with FR Bank or what other bank, the court could not subpoena. They petitioned the Supreme Court to quash that subpoena this sticker, so that their financial record will not be. And the Supreme Court was clear that you cannot enjoy that privilege. That constitutional privilege does not apply to you. And so I am of the opinion that the Supreme Court will not go back on this particular ruling. They will affirm the ruling of the lower court, and the Clar Foundation will eventually surrender whatever document they have in their possession to AREPT to do their investigation.
Do you see any difference in the two cases? In this case, there is not a formal trial. There is not a formal trial yet. In the case of Vani Sherman, there was a trial ongoing. There was a trial ongoing, and evidence was being gathered, and by all means they have to be very transparent and open, because ongoing trial involves discovery and everything. So there are two different scenario here, and sometimes precedents, depending on the particular circumstance, can be overturned, or just adjusted, or what we call the general rule and the exception to the rules. Do you see possibly that there could be some kind of trigger by the different circumstance?
Well, I don't see any much difference in terms of the scenario, because the first thing, the two entities, the Sherman law firm, and because it was Vani Sherman law firm versus the Republic of Liberia, because it was Sherman law firm that performed the legal services, for Sapo Mani. All right. So they were, and then the Clar Foundation, the similarity that I see is both of them are all creature of state statutory provision. They were all organized, the Clar Foundation, the Vani Sherman, the Sherman law firm, all organized under the law of Liberia, under the Business Association law of Liberia. And by virtue of that, the state reserved the right at any point in time, because they are all within the regulatory, framework of the state. So whether the only reason why because Ellen at that time constituted a special task force to investigate the Sapo Mani issue. The task force saw that, maybe the task force initially might have even requested Vani to produce evidence, and maybe they refused not to. So that could, but again, until it is clear, but I don't see the fact that they all are subjected to the regulation of the state. It doesn't matter how you approach it, whether you go strictly to court or directly you subpoena them, you ask them to bring their document, because the first thing is they are subject to regulation. And when you are subject to regulation, it means that how can the government regulate you? What is part of the government regulation? Boy, you are opportune, you are here, reading jurisprudence here, you understand the internal affairs doctrine of the state, on a corporate law. Yeah, it is the states, all entities, corporations, LLC, and all of that are organized under the internal affairs doctrine of the states. So that internal affairs doctrine, the state regulates to know, your board of directors and all of that stuff that you do, it falls under the internal affairs doctrine. And then the police power. Outside of the internal affairs, the state has a police power under the attorney general of the state to summon a particular corporation. If they see even an apparent of fraud, they can summon you. And so once you are subject to regulation, you don't necessarily have to go to court before you can exercise that regulatory authority. You can exercise that regulatory authority at any time. So
So, do you see a smoking gun yet? Because when
I mean, are not going to put Clar
no,
foundation to say no, no.
let me lay the
We are discussing the law. The law we are discussing. I
no,
don't
no,
see
no,
any smoking
no,
gun.
no. I'm gonna lay a premise on this question, and that it's a smoking gun question. But do you
Okay.
know if you get a private entity? Because uh, I'm holding show that Claria Foundation is running on the family. Claria, the family foundation, is a private entity. She built a whole village. They said Claria Hope Village or something they call it, and
Where?
the foundation. It's all they got a lot of they got school, they build buildings, and got people living there.
In
They got
Liberia
kids.
or other parts of the world?
Yeah, in Liberia, it's
Okay.
a
Okay.
village they call the Hope Village or something.
Yeah,
Yeah,
Clar Hope Foundation.
the Hope Foundation. So she got people. It's an entity running like a private stuff, but it's called a foundation. I think the kids don't pay school fee. I guess they go there free and then be sponsored by the foundation. But if government requesting how you get your funding and how you acquire those, you know, property and stuff, making a formal request, and you attempt to fight this request all the way to the Supreme Court, that raises red flag. Do you see a smoking gun in this incident? Because the family, they were in power, just, there's a lot of corruption cases, and the government is trying to connect the dot. You can see the as a recurring thing. There have been a lot of people associated with the past government in corruption cases and things, and a lot of that being connected to all of the money laundering and how they had the business. Do you see? I don't want you to speculate, but if you just give your legal, when people fighting on certain things that don't need to be fight on, because the law is clear. The government can subpoena your document if they don't find it in the record. Huh? It's clear. They are not covered to say that they can produce document and they consider it as evidence against them. It's not evidence. They're saying I'm producing evidence against myself. No, the government have the right to ask you for your document. Like a policeman on the road, and pull you over and say, "Can I get your proof of insurance or your car document?" You say, "No, I can't produce evidence. You have to go find it in the database." No, I think how it sound like, go to the DFB and find my document in the database, or go. So how it sound like. Do you see? Because they fight it all the way to the Supreme Court, and the Supreme Court have passed a ruling. Do you see something and red flag or some smoking gun in this scenario or this case?
It is the entity's right to challenge the status quo. And that's why we have the court system. All I can say is I want both, people on both are, especially those on the other side in the defendant position, to have an open mind. I'm not a fan of this government. I know I supported you initially, but from the let go, things are moving different ways. So I withdrew my support. I'm on my own now. But the fact of the matter is, if I were part of the legal team of the Claria Foundation, I would have advised my client that given all of this, I don't think, we need to fight it a different way rather than to see that we can challenge it. Because the first thing they should have understood, they did Article 21, self-incrimination. Does it apply to human being? The evidence is not being, except if the AREPT, they requesting the evidence from Claire Weir herself as a person, then of course, Claire can raise that constitutional, she is covered under that constitutional provision. But again, Is that testimonial or that physical evidence they are requesting? So yeah, you may say, I am I am protected under the Constitution now to produce evidence against myself. Which type of evidence in question? We go to that next level. Are we talking about testimonial evidence by talking or talking against yourself to provide evidence, or documentation? So if that documentation, then of course you will not still enjoy that protection under the constitutional provision, because they are asking for document, and that is not self-incrimination. So in the case, it's good. And as Comrade Willie said, maybe the Supreme Court, because it's a new code now, at the time was said that I know Kokpo code that ran, I think our Kokpo code that the Vanish Shema case, it was the Kokpo or Kokpo code. I'm sorry, Mr. Former
Yeah.
Chief Justice, if I, that was the code, I'm sure. Now this is the new code. Who is now there? That Justice Wu.
Are they seeing people?
I see
No, the
some
new Chief Justice.
Ifronima.
the
Okay.
Supreme Court justice, the lady retired. How to call
Sianyina is no more there.
You know,
her?
man,
Yeah,
we were talking about Kokpo, the Vanish
Yeah,
yeah,
case.
Kokpo was there.
uh,
Kokpo was there during the Vanish Shema time. Now Kokpo
yeah,
not
the
there.
lady I just retired.
Yeah, so
Uh,
they put
so,
the new justice there. So that court, they honor
yeah,
the
a Prophet Key course.
yeah. What is what, the prophet King Supreme Court, the
Yeah, the
prophet King
Prophet
Supreme, yeah, the
because
prophet King Supreme
the
Court
Supreme
could
Court
look
are the
into
first
it.
power on real, freedom of speech and stuff that was uncovered.
Yeah, yeah,
So they get a
the
Well,
prophet King Supreme
I
Court
don't know. Yeah, okay. Yeah,
could
go
look at it and rule differently,
ahead.
but I find it I find it hard that they will rule differently, because the law is clear. And I don't think the foundation can get out of the net in terms of producing the evidence. I mean, the document they're requesting for.
How do you look at the fact that AREPT is not established by the statute, and that there are other statutory bodies uh, that are around, like the LACC. Now, whether AREPT can exercise that much power when it is not established by a statute. Don't you think
Yeah.
that this is an issue that can be raised in terms of the overreach? Because RNI is asking for uh, the documents from the foundation, whether it has that much power to request a document from a private foundation, so to speak. I remember sometimes ago, this lady, Finabono, took a case to the Supreme Court challenging the power of AREPT, saying that the entity was a duplication of function. I don't
the
know.
asset.
I don't know
Yeah,
specifically how the Supreme Court rule on that, or whether they have ruled on that in any way, but that was one of the issues that she took to the Supreme Court. So looking at that, also I was thinking whether the asset recovery team has that much power to be able to request uh, the document, since it was not established by a statute.
Comrade Jones, you wanted to say something?
yeah. No, the men were using the acronym the ARAG. So, and a lot of people don't really know.
Yeah, asset recovery team. Yeah.
Yeah, I wanted him to call the full name asset recurring thing. Yeah, just to add to that little bit information, I think I followed that Finabono case. I think it went to not Supreme Court. I think it went to some court, and the manner in which the these guys went on the street and just start to impound all the car, yellow taxi that claim to be Finabon, and the people would do the register on the transport ministry, the how they call vehicle registration was clear, and they just claimed that it was almost, I don't know how many 50 or 100 of these taxis, and say for one person, and then they assumed that the person got the money from some illegal means, and they try to impound this guy. The process was completely wrong. So I think they could look into it, and all the car were impounded, were free the next day. So the case is an ongoing case. So now the asset recovery thing, I think they were over serious the first time. They didn't want on the street blacking people. I remember the former police director, all you know, car were arrested, and they don't understand the process that sometimes government gets so rude. After you use the car for 3 years, you can purchase the car from the same government. And because after the car depreciation of the car, and they come with some value of the car, and they sell it to, maybe a lot of people bought cars from government like that. So the process was, they have to say that the process was wrong, and and now I think the president get the power to give executive orders to form different group to investigate. So the asset recovery stuff is one of the executive power the president have to, have in his own purview to, if he deems something is like an ad hoc, like a special group that the president can come together and say this, I'm forming a group just for this particular function. They don't have, I don't know, from my own understanding, they don't have to go through a statutory stuff for the president to execute executive order on certain things that go wrong. But Professor Kofa can speak to the legal aspect of being statutory, if they have the right to, request for people document if they deem that they defraud government from some asset.
Yeah, I mean, in my understanding, when the president creates by executive order an entity to undertake a particular tax, what comes to my mind is that particular entity carries with it executive authority because it's a delegation. The president cannot be all over the place to do everything at the same time. So, as part of the powers that the president has through an executive order, he said, okay, I give it to this particular entity to do it. So, let's take for instance, if they want to challenge, I think it will still be a slippery slope for them because Arab is not acting outside of constitutional, it's not acting outside of the constitutional confine because they are created by an executive order, and the constitution gave that power to the president to issue executive orders. So, as part of that delegation, the president, through an executive order, establishes AREPT. Whether there is a kind of limitation on the executive power, to what extent they can go, to what extent they cannot go, I mean, it's something that can be tested. And it's only the Supreme Court or the courts that can interpret the executive power of the president as it relates to Arab. But until then, in my opinion, Arab is still within the confine of the law because it has been established and that executive order has not expired. If the executive order had expired, maybe, and they stay acting, then they can raise an issue of where their authority is coming from. But as it stands, the executive order is still in full stream. It has not expired. And so they are acting within that executive order. So to challenge that, it would not be a bad thing to challenge it, but I don't see the possibility that it can, they can win with that.
Yes, I think in any case, what we are witnessing in Liberia currently is a strong precedent against official corruption, and to the extent that the state can be able to go after past officials, uh, dig into their establishment, collect, request documents as part of their investigation to establish whether or not corruption took place. So the Supreme Court decision will make a strong determination with regards to that, and that could be precedent that could be used moving forward in the fight against corruption. So the way I look at it is that even the questioning of public officials who built those huge uh, hotels and other facilities, there could be question about the funding sources. So, because here is the thing, the Clar Foundation is more or less like placed against the wall to say, why the public should not believe that you use public money to build this structure. So if you think that you didn't use public money to build this structure, let's review your files. So similar argument could be made with respect to other public officials, whether it's with the WIA administration or the Bwaka administration. They can still do similar thing, or even the Alien administration, they can still do some similar thing, requesting accountability when suspicion, there is probable cause to suspect that, uh, or reasonable suspicion that you mismanaged or misappropriated public funds, and you benefited from that misappropriation. So this is a very decisive case that we need to watch very keenly.
Yeah,
Yeah,
that
that's
was
true. Go ahead.
strong wanting to public official based on this case because I think in a sense of being ethical in government, I think if you occupy certain government position, I don't think you are allowed to be actively involved in business venture like acquiring property. Like say the chief justice, and you stay acquiring property, or if you have your business before you went to the position, I think you have to. Usually you put that business in trust or put it in somebody's name to run it or something like that. But I've seen people in position of speakers and deputy speakers. They
So why are
build
you making an example of the chief justice? Why are
no
you using
because
the chief
that
justice
said that
name?
certain thing that Prophet Keith said they need to be investigated. I think Yaka Koliva brought
You
but in
still you
on.
still concerned with your member Veki?
No, I'm concerned because people take away. I don't agree with what the way Professor Key expressed his feelings on things in the way he expressed his thought. But sometimes I do listen to some of the logic that he puts when
Mhm.
he's not in that combative move, and sometimes he says something that makes sense. And one of the things it borders on ethical violation. You cannot be the Supreme Court judge and acquiring property and you actually involved into deciding a lot of people fate. Yeah, it's simple. Like the speaker of the house, the deputy speaker, the building university, they involved in actually running businesses. Those entities should be put in trust of some people running for them or they can be after they acquiring property. Even the vice president, and when he was in the House of Representatives, the House of Senate, they say he was actually involved into a lot of stuff. It's a conflict of interest. They decide the country money how it will be used, and they're running bigger entity. They have influence in making judgment on how the taxpayer money will be spent, and they're running the big entity. Maybe, like I said, the chief justice that maybe some people having conference and maybe a justice conference. You could say, "Y'all go use my hotel." You can't be running there. You can use influence, for people to win. Like the people accused Donald Trump one time when people goes to Florida, and he want for the people to run his and the Secret Service to be in his golf course, and millions of dollars are being paid to him. That's wrong.
Uh,
That's wrong.
I
So
think, Professor Kofa.
Yeah,
yeah,
I agree with you, but and this is a good case, to set the basis for our jurisprudence in Liberia. Um, let's see how it plays out now. The Clar Foundation has gone to the Supreme Court. We are looking, but I mean, from looking at uh, few cases, Liberian cases, and the way the Supreme Court has ruled, and then the recent case of Vanny Sherman, I think this would be another case to reinforce the Vanny case, or a big, a little departure from that. We are looking to see, but I mean, the court will, in my opinion, will affirm the lower court, because even in this country here, the Fifth Amendment does not apply to corporation. Corporation can they can't invoke the Fifth Amendment against self-incrimination. No, they don't apply because they are regulated by the state. So, but the virtue of the fact that they are under state regulation, the state can ask for document as part of their regulatory authority to see what they are doing. But we wait and see what the Supreme Court will do. Just few seconds. Orlando, I agree with you, but you know what? Fala then, the other guy who is the senator for Monserrato, they joined the unit, they aligning with the Unity Party because they don't want, if they are still in the CDC, ARA will go after them. So the fact that they are aligning with Joseph Boakai, they are protecting their establishment, and it shouldn't be like that. And this is where I have serious problem with Martin. If you want to go and retrieve or recover property, it should be across. Don't target only a few group of people. Okay? If you really need serious to retrieve Liberian people property that you think people taking, as you said, yeah, Fala, then they're sitting there. They were empowered, they build universities. The other guy, the senior senator for Monserrato County, now
Joseph.
just like Joseph, he got businesses all over the place. These are the things ARA should be investigating. But since two times now, the president issued executive order for ARA. The only when I announced Bono, then that Clar Foundation, which doesn't sound good because you need to balance the thing. But again, Martin got to protect his job because when you start going after Unity Party people, they will fire him from that place. So he got to focus on CDC.
Yeah, he has no tenure. He has no tenure.
Yeah, it's not a tenure. It's executive
He has no
order.
tenure.
Anytime the president
And that is one of the reasons why they can't use the LACC, because they're not protected.
Yeah.
Yes, but that's a fair comment. But whatsoever the case is, like you can take on all of the cases at once. But once the precedence is established, even people like Fala and Jeremiah Kuhn and Prince Moy and how you call him, or Emmanuel Nukwe, and the rest of the guys who are controlling the national cake,
Mhm.
they are not going to be exempted from prosecution because the precedents will be established. But this is a good thing.
They said they're trying to remove the statutory restriction, the statute of limitation for investigating. I think that I heard it, but then we also know that our laws are not retroactive. So
Yeah.
which point now? So when that statute is passed, we just start from the time it was passed forward, or how
What,
are they going to
but
do it?
when do you when does uh, the when do you start to count? When does
Well,
the
when
time
when
start to
when when
run?
it has come to the attention of the government that corruption
Yeah.
has been,
So the government can say, "Oh, they didn't come to our attention until now." But
Yeah, because I
you
listened
can't. But
to
you can't argue that. You can't argue that when the GSC has conducted an audit, and that
Mhm.
audit was sent to the legislature, and the legislature deliberately kept the audit, like what Amara Kone and other people are doing, the how they call it, the public account committee. You keep the audit, and LACC cannot proceed with prosecution. At the end of the day, the the perpetrator or those people involved can argue that the statute of limitation started running since the audit was conducted.
It's a serious thing. They need to work around it because uh, it's hard, my man. All these guys got rich at the expense of the Liberian people, and then they flipping. Tomorrow when another regime comes, they will go to that regime just to protect their property. Yeah,
Yes.
boy, my man, I got 3 minutes. So that.
Yeah, so you can just
yeah,
wrap
well,
up. You can wrap
yeah,
up, and uh,
yeah,
we will continue.
that wrap up. Man.
Yeah.
That
No, not
we can.
you,
Yeah.
OJ, not you.
I going 7 too.
No, not you.
I
Yeah,
going
but
7.
I mean, tomorrow again will be here. Maybe we can look at another thing, my man. Yeah,
Yeah,
but just hit me up, Bo, when you get something. Maybe we can look at the Amara thing you're talking about. Even though I don't have enough details on it, or we can look at the statute. They say they're coming to remove the statutory provision and see all that stuff. But anyway, once you get something, you can just let me know so I can do a little research before coming up. Then we can talk about it.
yeah,
But it was a good conversation. As we said, we want to wait. These are just our own opinion. We are not the court. We can say the court can rule differently.
yeah.
But from all
That's
indication,
going on.
it's
Yeah,
a kind of uphill battle for the Clar Foundation. I don't see any kind of way that they can get out of it, especially being even if we go by the route that she was the immediate first lady, the issue is it was government, whether government funding into that project. I think that's the cardinal issue.
yeah,
They want to establish whether her own money build that foundation or government money. And if government money is there, then they want to see it as a government property and not a
yeah,
private property. I think that
Yeah,
way they
just
want.
quick picture before you go because honor. I realized that under the we are administration, if you go through the budget, the president of the first lady have budgeted the government of Liberia
Yeah,
budget
yeah.
some money.
These are the things that pointing. These are the things that pointing
And
to project that she undertook. And
yes,
that's why
yeah,
AREPT is investigating to make sure that part of that money that was allotted to her It's not part of that money that being used to build that place. That's so it's a difficult. If she receive money from the government and she running a private entity, I mean, it's not a bad thing, And let's establish a fact. For me, I don't think it's a bad thing for the government to investigate.
Yeah, because
Tomorrow, when the Unity Party is no more in power, it shouldn't be a bad thing when the next government go to FOIA to investigate that complex that is being built. Let people not say it's a wish hunt, because we are now opening the Pandora box. It's good for Liberia. It's good for our society, so that we can keep
good for
corruption.
Yeah, because they budgeted money for her in the Liberian budget, so it's a legitimate.
No, I agree, but I'm saying in FOIA, that Mano River bill.
But the president Joseph Baka addressed that FOIA thing in his
What did
annual
he say?
He put a price to it. And
he said on the EFBC that the people never wanted to tell him about the project because they thought that he would refuse the project.
For the finance by
the project was done on a clandestine circumstance. Imagine your staff your lieutenant don't want to tell you, to let you know.
And where they taking the money from? Where did they get the money from?
Liberian government.
Yeah, when something is financed by the Liberian government, you will see the traces in the budget, OJ.
Yeah,
but
they get other funds that Liberian government.
Right now we can't do anything. Maybe the next administration will set up a structure that will go after the funding.
Investigate that, right now that's because next administration, because the paper was not clear. He said they didn't tell him. Then where the funding came from, they asked him. He said Lofa University. So how, my man, we can talk that one later on, but let me let you guys go, because OJ, you can't escape with that one.
No. You are clear.
That's not your place, OJ. You're not in government. I'm more arguing and defend that one.
I'm saying that the president admitted to the process, and he makes some clarity.
Yeah, that is the government owned.
Everybody want to investigate in the next regime. They can investigate.
So once it's the government owned, we don't expect that he will live in it. You will not retire there.
No, but he said not his home.
Okay.
He said for government Liberia, not my government Liberia.
Yeah.
Okay. All right. Okay. All right, guys, my man. Tomorrow we'll hang out again. Let me go to the game.
I had a long day. You still hanging around?
No, you can leave. I will just close up. That's all.
Yeah, close up. That look for another topic tomorrow. So I will be,
Ladies and gentlemen, that was it for today. Very healthy discussion with Professor Anthony Amos Tiakofa and Orlando Jones. We're basically looking at the Clar Foundation versus Asset Recovery and Property Retrieval Task Force. We look at the question whether the subpoena duces taken issue at the request of AREPT and enforced by the Criminal Code A is lawful, or whether it was an overbroad and constitutionally defective intrusion into the private entity's rights. Those are the issues that we were looking at. The matter, of course, is now before the Supreme Court to make that determination. It is not our place to do so. The strongest argument for AREPT will be that it has the lawful mandate to investigate public assets misappropriation. Our stronger foundation is its being established by an executive order, and that it has the right to investigate suspected misuse of public funds, trace public assets, and recover unlawful converted properties. If the Clar Hope Foundation receive public funds, state resources, or assets linked to public office holder, ARA has a legitimate investigative basis. The government position would be that a non-profit organization connected to high public office cannot be immunized from scrutiny simply because it is privately owned. A judicial suspicion of the subpoena can also be called into question. AREPT did not unilaterally seize document. The subpoena was issued through Criminal Code A. This is very critical for us to understand what is happening. And the involvement of a court transformed the action from executive intrusion into judicially supervised process. Therefore, we can argue that due process was initiated and the foundation had opportunity to challenge, which it is doing now, and the motion to quash was heard and denied, which is part of the due process, and that procedural path strengthens the government case. The government can also look at issue of subpoena power being abroad in investigation. In the investigative stages, subpoena needs not prove wrongdoing. That you want to get the document does not necessarily mean that Clar Foundation is involved in any wrongdoing. They must only demonstrate relevance to a lawful inquiry. So the AREPT is trying to do a lawful inquiry, and the subpoena only needs to demonstrate that much. And the court traditionally gave adherence to investigative agencies at this stage. So AREPT has some valid argument that they can make. They can argue that the subpoena seek document relevant to determining whether public resources were misused, and that is a valid argument and is a sufficient threshold for them to be able to articulate. They can also go on the point that no Fifth Amendment equivalent for entities. Like a non-profit entity might not have or does not have personal privilege against self-incrimination, which Professor Kofa was trying to elaborate. And the records of an organization are generally producible. So the IRA can argue most of these issues. We do not know where the case is going to lean. The Supreme Court is going to make the decision on that, but generally, we are standing on the side of fighting corruption in our country. And so, on the other hand, the Clar Hope Foundation can argue that the AREPT is exceeding its authority and is acting ultra vires. So the foundation most powerful argument can be that AREPT exceeded its authority. The key question will be whether AREPT has statutory power, whether AREPT was statutorily empowered, because an entity that is statutorily empowered has more strength as compared to an entity that is established through an executive order. And if an entity established through executive order, probably come in conflict with an already established entity for the same reason, there can be a question of duplication. But who takes that issue to court is another, question, because the court is going to question whether you have standing to bring that issue. So the Clar Foundation can actually argue whether the AREP was acting within its scope and whether it followed required procedure before issuing the requested subpoena. So if the entity operate on an executive instrument, depending on whether it's the statute or a executive order, the weight of their coercive power, comes in question. So there can be another issue, talking about the way that AREP goes about with the questioning or requesting the subpoena, whether it is just merely going on fishing expedition or it is being very specific about what it is seeking. So because court would traditionally require subpoena to be narrowly tailored, relevant, and not unduly burdensome. Like you want the people to go and bring you all of their documents and stuff like that, that the court would not be able to tolerate. So if the subpoena is broad and unspecific, this argument will give some force that the court is going to look at, and there will be a due process concern, which IRA can be able to argue that they are already satisfied, and there will be a lot of question regarding the impartiality of this subpoena. There will be an issue of reputational and political risk, because although the reputational harm alone is insufficient to quash a subpoena, the foundation may argue on reputational ground that AREP is being selective, targeting entities associated with the prior administration alone. But I don't believe that it's going to make sufficient point for the Supreme Court to overturn the subpoena. So these are issues that AREP can be able to raise, and we are hoping that this case is going to strengthen our fight against corruption in Liberia, and that we are going to derive a huge benefit out of this case to be able to prosecute corruption in the future. The case will likely define the constitutional limit of Liberia's asset recovery regime, the strength of due process protection in financial investigation, and the balance between transparency and executive overreach. The Supreme Court might also look at structural governance cases not being merely a political one. We have to have some appreciation for what is happening in Liberia now, irrespective of which political uh, side you are leaning. This is a fight against corruption. Whether the whether Arab is right or wrong is going to be tested in court, and the law is going to take its course. In as much as we are not on the street fighting each other, it is a much better thing to do to channel all of our issues through the law. As we always say, Liberia is a country of law and not of men. We have to make maximal use of the law, and we hope that the judiciary remain very impartial in dispensing justice as we look forward to where this case is going to be heading. This has been Vote 24 TV, Kaki's Dialogue, the Kamara Abdullah Kamara Intellectual Dialogue, and we have served you this with all of what we possibly can, and we hope that you enjoyed the show today. It has been my pleasure hosting this program with Comrade Orlando Jones, talking with Professor Amos Tiakofa today. Thank you very much.